The United States Supreme Court has once again declined to hear a case that could have led to a revisiting of the legislated inequality between Americans born on the mainland and those in the territories. On Monday, the court announced that it would not be taking up Federación de Maestros de Puerto Rico versus Financial Oversight and Management Board for Puerto Rico. The Teachers Federation was fighting against unilateral cuts to their retirement system by the federally mandated board. The Oversight Board, imposed in 2016 by the Puerto Rico Oversight Management and Economic Stability Act, or PROMESA, had earlier this year received judicial approval for a territorial debt and pension restructuring plan that imposed cuts to the pension benefits of several classes of public worker, including Puerto Rico's teachers. According to the plan, future retirement benefits would be frozen and the legal retirement age raised. Teachers argued that their retirement framework was part of Puerto Rican law, and as such, the Oversight Board did not have the authority to overturn local laws to make those changes. The case went against the teachers in a ruling from the First Circuit Court of Appeals, which determined that PROMESA, the board's establishing legislation, expressly allowed the entity to ignore local law when making its financial management decisions for the territory. Apart from the immediate issue, legal observers believe that the case could also be a pathway for the Supreme Court to finally review and reverse a series of decisions from the early 1900s, collectively known as the Insular cases, that enshrined into law second-class citizenship for territorial residents. In effect, the Insular decisions means that the rights, freedoms, and status of residents of U.S. territories are determined exclusively by Congress and not the country's constitution. The teachers' appeal to the Supreme Court argued in part that this decision was an improper extension of the Insular cases, and the case was described as being the, quote, perfect opportunity to overrule the Insular cases. The Insular decisions have long been derided as bad jurisprudence by a host of legal scholars, including several sitting justices of the Supreme Court themselves. Neil Gorsuch wrote in a concurring opinion on United States versus Valle Madero, a case from 2021 determining that Congress was not compelled to extend certain Social Security benefits to Puerto Rico residents, that, quote, the Insular cases have no foundation in the Constitution and rest instead on racial stereotypes. They have no place in our law. Justice Gorsuch, in the same opinion, advised that, quote, the time has come to recognize that the Insular cases rest on a rotten foundation. In her dissenting opinion on that same case, Justice Sonia Sotomayor agreed with Gorsuch, writing that the Insular cases were, quote, premised on beliefs both odious and wrong. Both justices expressed hope that, quote, the day comes soon when the court squarely overrules them. However, by declining to hear Fitisimanu versus the United States earlier this year, which sought to establish birthright citizenship for people born in U.S. Samoa, and now by declining to hear this appeal by the Puerto Rican teaching establishment, the Supreme Court has ensured that the day it overrules the Insular cases remains an indistinct point in the future.